Afternoon, everybody, to this Seas at Risk webinar on fisheries measures in offshore MPAs. Thanks for participating. And for those who can't participate now, we'll record it so you can listen to it later. We've organized this webinar because of our project on fisheries measures in MPAs. I'll first explain a little bit about the context of this whole webinar. We are still in a situation that 6% of the EU marine waters have been designated as an MPA, but only a small fraction of these are effectively protected. Most of them are paper parks. Gradually, the member states are starting to understand the importance of putting in place fisheries management measures, amongst others thanks to NGO pressure, but there's still really a long way to go. So Seas at Risk, the Marine Conservation Society and Client Earth have been working together to raise awareness among European NGOs of the need to confront governments on the adoption of fisheries measurements in MPAs. And for that we organized already last year, September 2016, a workshop on the legal aspects of fisheries management measures in MPAs and when and how NGOs can intervene to push for stringent measures. But this workshop addressed specifically inshore Natura 2000 sites, MPAs designated under the Habitats Directive within the 12 nautical mile zones, where Article 6 of the Habitat Directive is crucial for the process. And you can find the proceedings and the presentations of this workshop on the SAR website, and I would encourage you to have a look there. But today we take a next step, we follow up on this, and today we really want to address fisheries measures in MPAs that are located beyond the 12 nautical mile limit. And in this case, there's other member states who may also have an interest in the fishery of that area. And therefore, the Common Fisheries Policy comes into sight, because this policy has a procedure that allows member states to adopt conservation measures in coordination with the member states that are fishing in the same area. This is Article 11 of the Common Fisheries Policy. And the problem is that there's a risk that these discussions and compromises take place behind closed doors, and that NGOs only find out about the measures proposed at a stage where it may be too late to influence them. So what we would like to do here today with this webinar is to explain how this procedure works that is laid down in Article 11 of the CFP and show where and how NGOs can intervene. We'll start with a presentation by Alice Peritz of Client Earth. She will explain the whole Article 11 process step by step and where the NGOs can intervene and the possible outcomes. And that will be followed by two interventions from members from Seas at Risk and that have already some experience. They have gone through this process in their country. Jean-Luc Solan from Marine Conservation Society will talk to us about the measures proposed by the UK in the southern North Sea. And Krien Hansen from Natuurpunt will present her views on the Belgian proposal for the conservation measures in the Belgian marine areas. And then after this, you come into play as the audience. There will be you then have the opportunity to ask questions. However, you're muted, so you have to type your questions in the webinar panel on your computer. And you have also to indicate to who this question is targeted, and then Alice Belin, who will moderate this session, will then read them aloud, and the panelists will be able to answer. So that's what we are looking at now. So with this, I would like to ask Alice of Client Earth if she would like to start her presentation.
Oh, thanks very much, Monica. That's great. Please do let me know, everybody, if you've got any trouble hearing me, because I am dialed in via a telephone rather than via my laptop, and so if it's too quiet or anything, please do let me know. So hopefully you can see everything on my screen, and I'm going to start by just talking to you a little bit about what Article 11 is and what we're trying to achieve with it. So I appreciate many of you might already be quite familiar with this, And so, I don't want to go into a ton of detail about the background, but also I just think it's important to just set it in context, because I think sometimes the reasons why we're using this can get a bit lost in worries about how the process works, how and when we can get involved. So I'm going to give you an idea of that, and then I'm going to move on to outlining at a high level when the process behind Article 11 will be triggered and what it entails. And then the body of the presentation will consider the process in more detail, going beyond the letter of the law to understand how the process tends to work in practice and how and when NGOs can most effectively influence the process. Right. So before reading out the text on the slide, I will just do what I've said I was going to do at the beginning, which is give a little bit of background about what we're trying to do here. So Article 11 is basically a tool to enable member states to implement management measures to control potentially damaging fishing activities in their waters. Now, why would member states want to do this? As we know, essentially it's in order to meet their legal obligations, which could be either and obligations under the Habitats Directive. So Article 6 of the Habitats Directive, as we know, places both negative and positive obligations on member states to avoid deterioration of European marine protected areas, so that's SACs and FPAs classified under the Birds Directive, and also to assess plans and projects and allow these to go ahead only where adverse effects on site integrity can be ruled out. So they might need to introduce measures to meet that obligation, and they might need to introduce obligations, measures to meet obligations under the Marine Strategy Framework Directive. And Article 13.4 of that directive requires member states to create spatial protection measures, in other words, marine protected areas in their waters, to try and contribute to meeting the overall objective of the Marine Strategy Framework Directive, which is to achieve good environmental status. So in the UK, we've got a network of domestic marine protected areas called marine conservation zones, for example. So going back to the slide in front of you, it is a roundabout way of basically saying that member states have to implement management measures in their own waters to meet their obligations that I've just talked about under the Habitats Directive, Birds Directive and/or Marine Strategy Framework Directive. And what the text says is that where those measures won't affect fishing vessels from other nations, they have the power to do this unilaterally, i.e. by themselves, without consulting with anyone or obtaining permission from anybody else. However, that situation changes a little bit if the measures being proposed are going to affect fishing vessels of other nations. So in the legislation, it phrases it as measures that will affect other member states having a direct management interest in the fishery to be affected by such measures. So it's basically what I've just said, other fishing vessels from other nations are going to be affected by the measures. So in those cases, the member state have to implement management measures by working together with those other member states who will be affected by the measures, and to try and produce something called a joint recommendation, which will set out the measures being proposed that have been agreed by all the parties and submit it to the Commission, who then have 3 months to either accept or reject that proposal, which we'll talk about later in more detail. So what we want to talk about now is what is the role of NGOs in this process. So, essentially, as I've said before, it's really important that NGOs are familiar with and understand the legal obligations with which member states are seeking to comply, i.e. the obligations of the Habitats Directive, Birds Directive and Marine Strategy Framework Directive. This is key to a successful campaign under Article 11, because if we don't know what those laws say, then we're not going to be able to argue for effective management measures, because that's the point of Article 11 and that's what we're trying to achieve. So NGOs then need to use this knowledge to monitor the Article 11 process and ensure, as far as possible, that management measures being proposed are compliant with those legal requirements. But the question is, how and when are NGOs most likely to be able to effectively influence this process? So this is why we've produced this mapping tool, which sets out in more detail how NGOs can get involved and what the different stages of the process are. Now, it's a bit difficult to kind of, put this down on paper really, because it's so meandering, but what we've tried to do is split it into 3 different stages, if you like. So the first stage is where the initiating member state who wants to implement the management measures gathers information and uses this and works together with, identifies the other member states that have got a management interest as well, and works together with them to prepare an initial proposal. And the second stage of the process is where there will be consultation, and a formal consultation with the other member states, with a view to producing a joint recommendation which is agreed by all parties. And then stage 3 is where the Commission considers either the joint recommendation, or if one couldn't be reached, the submission from the initiating member states, and I'll go into that later. And it talks about the different outcomes that could take place following that. And so also just to note at this early point in the presentation that it's particularly important for NGOs to be involved at the start of the process, so particularly in stage 1 and to a lesser extent in stage 2 as well, because these are the times when it's going to be really most likely to be successful in influencing the management measures that have been proposed. And also the later stages, involvement in the later stages carries a higher risk of undermining these proposals and meaning that everybody has to go back to the drawing board, and therefore no management measures at all are going to be put forward or agreed on. So it's very difficult really, because obviously we don't want to have management measures that are wildly far away from our legal obligations and requirements, but also in practical terms, some management, we have to accept some management is better than nothing on some occasions, but we can do our best to influence and to understand what the different timings are and when it's best to seek to exercise that influence. So there's a key here, because we're going to go on to the mapping tool in a moment, and as you can see, the blue actions are those that represent direct input to member state proposals from the Commission and stakeholders such as the fishing industry. Yellow actions represent a more indirect input to member state proposals, for example, via advice provided by conservation bodies, as in the ones that are sort of statutory conservation bodies in that country that provide conservation advice under legislation. And then the green arrows and bubbles, which you'll see what I'm talking about in a minute, relate to the NGO input and possibilities to influence the proposals. The distinction between the blue and yellow actions is a little bit artificial, but it's basically supposed to represent the distinction between the official consultation process, which is the blue bit really, and the background advice and input that might be sought and received outside of that process, which is the yellow, but is still separate from the NGO, the kind of informal NGO stuff going on, which is in green, although it could be informal and formal, as we'll see in a minute. So we're just talking about stage 1. We're going to explain, I'm going to just set out the Article 11 process and talk about the different stages and how it works without actually penciling in where the NGO input could happen to start with, just so we're all clear on how it all unfolds. So this is the stage where I talked about where information will be exchanged. We'll find out, which member states have got a direct interest and so on, with a view to trying to get together an initial proposal. So the initiating member state who needs to introduce conservation members will be looking to understand which other member states have a direct interest in the fishery that's going to be affected, and they will have to nominate within their own sort of government structures a department to help develop the measures, which could be environmental or fisheries, or may take be maybe a crossover between the two. And it may also take advice from its national conservation advisors. Here it's a bit unclear the role that's going to be played by the Commission in all of this. This is something that we are really seeking to clarify with them, but it's not really sure what, if any, input they would have at this stage. The member states that have a direct, interest in the management measures go through a similar process. They'll nominate their departments, they'll talk to national conservation advisors, and everybody at this stage is just in a flurry gathering information and views on what measures might be needed, what measures are acceptable, what the socio-economic impacts might be, all that sort of thing. So the next stage is the establishment of an informal group, which will include representatives from both the initiating member states and the other member states with a direct management interest, with a view to producing the initial proposal. And as part of that, there will be involvement from the relevant advisory council or councils. So just to explain that, but as probably you may or do already know, these are stakeholder-led organisations that include representatives from industry and other interest groups such as NGOs, and they're formed to provide the Commission and Member States with recommendations on fisheries management measures. That when you get sent round a copy of the presentation afterwards, there is a link in the notes which talks a bit more about the role of advisory councils and what advisory councils have been formed to date. So the aim is that all of these different actors and stakeholders come together to feed into producing a joint recommendation to submit to the Commission, but at the moment it's just in the format of an initial proposal for more formal consultation. So we're going to go through the process again and just look at how the NGOs can influence that process. So this slide is just talking about the fact that we want to seek to ensure compliance with the relevant legal requirements and the different ways that we might be able to do that. So by more formal letters, more informal exchanges of intelligence, and all of that sort of thing. So in this slide, you can see we've already got set out the same mapping, but now we're going to add in the green bubbles and arrows, which demonstrate how and when the best opportunities for NGO input and influence will arise. So you can look at this in more detail yourselves afterwards, but essentially what we're saying is at this point, early in the process, this is the best time to raise substantive points that different NGOs in different member states, in the initiating member states, but also in the other member states that have the fisheries management interest, this is the best time to raise the really substantive points about whether these proposals really comply with Article 6 of the Habitats Directive or the Marine Strategy Framework Directive, and also to put forward ecological knowledge and expertise which is going to contribute to an understanding of whether these management measures are compliant. And this is really the best time to do that when there's still a lot of scope to be shaping this initial proposal before it goes for formal consultation with the member states. So now we're going to move on to stage 2 of the process, which is the consultation on the formal proposal with other member states. This has to take place less than 6 months from an agreement that sufficient information has been provided, and once the initiating member state has presented its formal proposal, it has 6 months to work with other member states to prepare a joint recommendation. Either member states with a direct management interest will agree to prepare a joint recommendation and work collaboratively with the initiating member state to do so via the member state group, or member states with a direct management interest may not agree to make a joint recommendation, and the proposal of the initiating member state becomes a formal proposal to the Commission. So let's just have a look at the different stages here. So as you can see, it's all very similar to what we've seen before on the other slides, with all the same actors here going through the same processes, except this time it's a formal consultation. So now moving on to how and when the NGOs can influence this part of the process. So this is a very similar slide to previously, and basically what we're talking about is at this point there is still a chance for the NGOs to have an input on substantive points. However, they're less likely to be taken into account at this stage, and there is a risk that the process, there's a smaller risk, but it's still a risk that the process could be derailed. So at this point, the best thing to do is to respond to the formal consultation in their capacity as NGOs, but also potentially through roles on the advisory council and so on. But there isn't really as much that can be done at this point in terms of influencing in a more informal capacity, and you've got to be very careful to tread a line with the consultation response between criticising these proposals and their compliance with the relevant legal obligations and completely derailing everything by saying that the proposals are terrible and they're completely non-compliant, and putting a lot of pressure on to go back to the drawing board. So I think it's kind of picking your battles at this stage. Obviously if there are major inconsistencies with the legal requirements, these have got to be pointed out at this stage, but just we've got to try and have a supportive role at this stage, and rather than the perhaps more attacking role that the NGOs could take at stage one. So moving on to the third part of the process. So there are two different outcomes really at this stage. So either all of the member states and the initiating member states come to an agreement and they submit a joint recommendation to the Commission, or an agreement can't be reached, and therefore at this point the initiating member state has to form its own proposal by itself and submit that to the Commission. So we're talking about outcome one here, where the joint recommendation has been agreed and everybody works together on this and it's submitted to the Commission. So what happens now is the Commission will either approve or reject this joint recommendation. So during this time it will take advice from scientific advisors, in particular the Scientific, Technical and Economic Committee for Fisheries, and may also consult other fora such as the Habitat Committee. So if this is approved, then the Commission will adopt the measures through a delegated act, and there is a possibility still at this point that it could be vetoed by the Council or the European Parliament, and but hopefully not. And if it's rejected, then the Commission embarks on quite a lengthy legislative proposal drafting process. This is not a good outcome, because if the Commission does this, it's going to take a lot of time to draft this legislative process, in which time there's no management, and also it's a bit risky because politically it's unlikely that stronger management measures than the ones that could have been or were proposed by the member state are going to be agreed or recommended or implemented, really, is what I mean. So this is sort of the kind of worst case scenario in a way. And so the second outcome that I've talked about is that there's no joint recommendation submitted, and instead the initiating member state submits a formal proposal on its own. And again, the sort of outcomes at that point are the same. So either the Commission will adopt it, or it will reject it and come up with its own legislative proposal. So I appreciate that's a bit of a kind of run through everything, and potentially you might have a few questions or clarifications that you want, but to just kind of finalise what I've been talking about and give a bit of a summary. So the point of the Article 11 process is to basically ensure that member states can meet their legal obligations under the Habitats and Birds Directives and the Marine Strategy Framework Directive. The best chance that NGOs have got of influencing those proposals and ensuring that they are compliant with the relevant legal requirements is near the beginning of the process, particularly at the informal consultation stage, but also at formal consultation stage. But at that point, a bit more of a pragmatic line needs to be trod. And here, actually, it would be, I didn't say this during the presentation, but it'd be good to raise the fact that at this point in the process, at stage 2, it's completely legitimate to be raising procedural points, as I would call them. So NGOs from other member states that have direct management interest can support the process by seeking to influence their own governments to accept the proposal being put forward by the initiating member state. And I would call this a sort of procedural facilitation, and any number of supporting letters, which is something that we have been working on as a group to try and empower NGOs to do, could be sent, and there's no harm in that, but it's just treading the line when you're making substantive points between pointing out obviously big gaps or non-compliances, but also picking your battles and not derailing the whole process so that we have to go back to the drawing board and it delays management measures still further. And then the hope is that agreement can be reached and a sensible joint recommendation can be put forward that's likely to be accepted by the Commission, because if it's not accepted, then the risk is that a very lengthy legislative procedure proposal drafting process is embarked on by the Commission, which then delays the process still further and again delays adoption of management measures to protect our vulnerable habitats and species. So that's everything. Thanks very much.
Thank you very much, Alice, for this very comprehensive and very clear presentation, and for the last bit of information you gave us there. What we'll do is that we'll take questions at the end of all presentations, but if our attendees have questions, remember that you can type them in the webinar panel and you can address them to all of our different presenters. So now, Jean-Luc, if you are ready, I would like to share your screen. Yeah?
Yeah.
Okay. There we go. And you can start your presentation.
Okay, hello. So I'm, as Alice alluded to, try and think about the process of what she described and how we are influencing the process for these southern North Sea sites. This leads up to the point at which the initiating member state, in this case the UK, has just offered the formal proposal for the Commission to start the formal consultation process. So we haven't even done the formal consultation on this, but the information has been gathered sufficient to satisfy the advisory groups and the other member states in the initial proposal. So it's early, it's somewhat early, but this is how it's progressed for these very large offshore sites off of the east coast of the UK. So I'll just go down a slide, hopefully it'll work. There we go. So quite interestingly, what the Commission has given guidance on is the level of information that an initiating member state should gather that it satisfies the required information level to start a formal procedure. And these, ironically, are 11 tests to satisfy Article 11. So numbers 1 and 2 are generally set by the Nature Conservation Advisor of the initiating member state to show the natural features and the conservation objectives to protect those features. The Nature Conservation Agency as well will give a sense of what the spatial extent of the boundaries should be around those conservation features such as, for example, sandbank sites and offshore sites, in order to be protective of those features. They may extend beyond the actual extent of the feature, but satisfy that they might be slightly outside or inside, but not necessarily in straight lines, because biology is a straight line. So there will be an element of precaution, perhaps, in the extent of the boundaries that they advise should be set up within the sites. And then threats to the habitats and species from different fishing gears will again be offered by the Nature Conservation Agency. And in this case, for the Southern North Sea sites, DEFRA has gained information from the European Commission of fleet activity in the area by nation, the type of gear, the species that are being targeted by those nations and gears. So there's a really comprehensive evidence base of what's being fished for and where. And that information has to be gathered for over 3 years. And that's really the information gathering process to understand the extent of the features and the threat from different fleets to those features. That then leads to proportionate and enforceable management measures to maintain or achieve favourable conservation status for European marine sites in those areas. There might be slightly different measures have to be undertaken for domestic legislation that set up their own domestic MPAs. But of course, as Alice alluded to, we're meant to get to good environmental status for the entirety of the MPA network and the entirety of EU seas under the MSFT anyway. So MPAs are a major contributor to that. And then the initiating member state, through its government agency, department, will consider control measures. It could be vessel monitoring schemes, increased transpondence rate from vessels above the baseline, which is about a transpond rate of about once per 2 hours. UK, for example, has increased that transpond rate to about 1 transpondent every 10 minutes when it gets within a certain range of where the threatened features are as a recommendation. Number 9, the member state will look into measures to monitor and assess the feature condition, see how it does relevant to the management measures that have been set up. Coordination, number 10, and importantly, evaluation of display, number 11, which of course you will all understand is an issue for fishing fleets and will always argue against marine protected areas of management because of the concerns of displacement. So it's a comprehensive list of information that in this case, in the Southern North Sea, has been satisfied according to the other initiating member state civil servants who sit on the group that review this before it goes to formal consultation. So the sites that I'm going to talk about are, I'm going to use my mouse a little bit here to describe. I think you can probably see it moving around a bit there on the first map at the top left. Let me just talk about the process a bit. So the first informal consultation on these 5 sites, I'm going to look at them here. The 2 ones in pink here are domestic sites set up under UK laws, the Marine and Coastal Access Act. They're called Marine Conservation Zones. And then 3 or 4, depending on how pedantic you are, offshore sites, sorry, these 3 here, which are wholly in the outside of 12 nautical miles, well, mostly outside 12 nautical miles. So they had issues for many member states, particularly the Dutch, Belgians, and Danish. Danish were particularly interested in these northern North Sea sites. Now, the features protected in these sites were pretty much sand and mud features under the domestic legislation, and these southern North Sea sites here are reef and sandbank features under the European Marine Site designation. Most of you will be familiar with that. Dogger Bank, as you well know, is part of a much wider area that goes way into Dutch, German and Danish waters, so it has its own process, which is separate from this process. So it's unique. We don't have to be too concerned about it for the purpose of this workshop. Under the pink states, under domestic legislation, the UK had already satisfied socioeconomic concerns. It has said within discussions with other member states by actually doing a process of consultation through the actual designation of the sites, whereas, as you might well know, European marine sites are set up primarily with scientific or ecological reasons, and socioeconomic impacts are taken into account thereafter. So very interesting differences between the actual socioeconomic input of these two sites compared to these three sites I'll talk about in a little bit later. And those sites are also demonstrated to a much higher resolution. The southern North Sea sites here are in this map here with SPAs in blue that I'm not going to really talk about today, but the management measures for these three large sites I will be. And you can see the slight hash marks here are where you have the input of the offshore over 50-meter fleet. And you can see there's an overlap between the activity of the towed gear fleet, principally pulse trawling from Holland, we believe, in these two sites, North Norfolk Sandbanks and also the Haysborough, Hammond and Winston. So DEFRA had collated all the evidence on the actual physical location of the features, but also presented in this workshop in May, where the features intercepted with the sites. Very important that we had such a high resolution level of information that we could see stakeholders very early on in the process to understand where the imminent threats, real threats are to favourable conservation status of these features. Now, after the initial maps were shown of showing the overlay of where the fishing effects are related to the features, an informal consultation phase was made by the Nature Conservation Advisor called JNCC, UK government, and DEFRA, the government body itself. And in October 2015, after that, starting the process in 2015, they refined some of the actual towed gear closure proposal areas within the site. And new areas within the boundary were considered. Most excitingly of all, in terms of measures which meet Article 6 requirements and site integrity arguments in law, we were seeing much more expansive measures. If you can see my mouse here, around the Sagillaria reefs, which are a mobile reef or ephemeral reef. They come and go, and our arguments to DEFRA and to the agencies concerned in terms of the law and ecology were that we couldn't be certain that the tow gear wasn't restricting the reefs to an artificially small extent. That argument, I think, has had good effects for our conservation measures, because we see much more expansive boxes around this area, for example, and around this area between the reefs, arguing strongly that by allowing tow gear between these areas, we are reducing the opportunity for the reef to re-establish or grow. And that is a very key argument to site integrity, that we should allow for the natural conditions and the species that need those conditions to be naturalized to prevail, to exist, grow, reproduce, and then host all sorts of other species. So this was really a great opportunity for us when we were offered the first maps to show that we should go further with our conservation measures. There is, as you will have noticed, unfortunately, a large area here where my mouse is hovering now, which is completely open to tow gear. And our arguments made, as Alice was saying, were that this is not meeting site integrity requirements for the entirety of the site and features, but is better than nothing. Again, being sure to be pragmatic, where we could lose everything if we said just reject the entire proposal. That's something that other member state NGOs might be disappointed in, but it's just the reality of the day. And then to go on another 9 months or so, there was an ad hoc meeting of the Scheveningen group. Now, I think Alice brought in her map an advisory group that all this information feeds to, that is hosted, if you like, or chaired by the initiating member state and includes other member state civil servants. And I went to a meeting in September 2016, just before DEFRA was wanting to initiate the formal process. So it was kind of like a sign-off meeting, if you like. And there, for example, Denmark, in the first bullet point, called on more up-to-date fishing data. Sweden made a formal declaration that pelagic sand eel fisheries data should be included. These sound like these are quite minor points, but they can also cost time of the process, of course. As a sort of something we were not particularly pleased about, the third point, all measures in all sites would allow for a type of fishing called Scottish seining within all parts of the sandbank features of sites. Not the reefs, but the sandbank features of the sites. And this, it definitely argued, was equivalent to the measures that they were considering within the Dogger Bank. The fourth bullet point, at the end of 2016, the process was very close to sign off, but for the questions of a fishing effort by Denmark and Sweden. At this point, we thought it was relevant in our own organisation to send letters to all North Sea member state fishing nations calling on support from their ministries, so that's environment and fisheries, to UK measures in the offshore sites which were affecting their fishermen. And we received responses from Germany, Denmark and the European Commission. That has led to Seas at Risk through this project, and it will be available on their website, providing template letters started by Client Earth for other member state NGOs to support the UK process for these southern North Sea sites. Now, that is still, I think, a valid situation because of formal processes beginning, and we can maybe talk about this in the wrap up, but sign off on the measures from the beginning of the formal Commission consultation started about 3 weeks ago. So we will probably hear formally, to a certain degree, how these proposals are going and what they look like, but informally much of the process has happened and we should see some form of agreement, particularly at the level of civil service. Now, I also have to mention that MCS Scottish office also engaged other member state NGOs, fishing representatives to support the Scottish MPA management measures since 2014, and that has led to protection of vast areas, or should lead to protection of vast areas of particularly reef habitat in Scottish waters, and to a certain extent sandbank features. So there is progress. It's not as good as we'd like, but there is progress. There are other offshore site processes that are taking place that are slightly different from the Article 11 process, because there is this zone within UK waters within 6 to 12 miles that doesn't actually lead to the Article 11 process. So, and it touches on the sites just here where my mouse is at the moment, in one site down there. There are sites here that are relevant to this zone, and some sites in Cornwall where we can initiate our own management measures, but we have to inform other fleet about those activities. There's also been pretty well agreed measures for sites in the Irish Sea, here where my mouse is now. I've mentioned the Scottish offshore process, which has seen representation from many other member states, the Dutch, French, Danish and Spanish. My colleague Callum Duncan, who's listening in on this, is able to talk to you about that, no doubt, in further detail if you need to. And just to reiterate, this is the last bullet point of all, as Alice alluded to, our letters of response to the North Sea process are providing a balanced, pragmatic approach in our thinking that protecting something is better than nothing. But nonetheless, we must be sure to emphasize in our letters the legal requirements that we know aren't really being met by partial protection of sites and partial protection of features unless regulators and governments are certain there will be no adverse effect to site integrity. So whether it's an argument that is couched in Article 6 of the Habitats Directive, which is within site integrity points, or it's a domestic site which is set up with other legal articles which don't push the site integrity point, we've used the same arguments, because if we just have partial protections of sites, we won't see the full benefit of the ecosystem returning to a functional and ecological level at which it would be, we believe, in the absence of particularly bottom-towed fishing gear. So I don't know how much we've influenced the process or the measures in detail, but it's certain that we have had some impact, and it is through, as Alice said, the informal process by which we've had that influenced. So I think that's enough from me. I'm happy to take questions at the end and clarifications. Thank you.
Thank you very much, Jean-Luc, for your presentation. And yes, indeed, I'll encourage our attendees to ask you questions in writing, and then I will read them out loud at the end after we've done with our presentations. So now we will go to the presentation by Kreen. And Kreen, I will show your presentation on my screen now. And you can start whenever you're ready. Yeah?
Yes, thank you, Alice, and welcome in Belgium, everybody. I will explain the difficulties we experienced in Belgium with the Article 11 procedure. So, next slide, please. Interesting in the Belgian case is that the fisheries measures in Belgian waters, they are a part of the Marine Spatial Plan. And here you see the overview of the Marine Spatial Plan. Now, to give you an idea of the total surface of our Belgian part of the North Sea, it's quite small. Our shoreline stretches only for 67 kilometers. So it's a small part, and as you can see, there are a lot of activities taking place in the Belgian part of the North Sea. Now, when we take a closer look at the nature and fisheries measures, that will be on the next slide. On the left-hand side, you see the fisheries measures, and when you click again, yes, on the right-hand side, you see the fisheries regulations. The green area is the Nature 2000 area. It's called Vlaamse Banken, and it's quite big. It's in total, it's about 30% of the total surface of the Belgian part of the North Sea, but it's mostly a paper park. The purple areas are the areas for renewable energy. Now, you see the maps are quite they look the same for nature and fisheries, which is a bit strange. But when we take a closer look in the next slides to the fisheries measures, we see that there are only 5 zones with fisheries measures, and at the moment when the Marine Spatial Plan was written, we didn't have a management plan for the Nature 2000 site yet. So all the measures, they are based on MSFD, more precisely descriptor 6, seafloor integrity. And the middle line is the 12 nautical mile zone. So above there you see the zones 3 and 4. That are the only offshore zones in the whole story, and those are also the most valuable zones in our Nature 2000 sites, because there are still some remains of gravel beds, and there our historical oyster grounds, they were situated there in those 2 zones. But when you look at the fishery measures, you see zone 3, it will be closed, or it should be closed totally for non-seabed disturbing fishing gear, which is okay. But zone 4, it should only be used by non-seabed disturbing fishing gear. But in MSP, it says that that should also be a testing zone for alternative fishing techniques. Through a permit system. But yes, it's a bit strange to allow testing in the valuable zone, I believe. I won't go that much in detail in the specific fishery measure because I think it would take us too far. But in the next slide, you see what happened during the Article 11 procedure. This slide is based on the joint recommendations that were written in October 2016, and I know they are, at this moment, they are submitted to the European Commission. Now, when you look at the measures in the joint recommendations, you see the green marks, they are okay. The red ones are a big problem, and the problem is zone 3 and 4, the most valuable zones, where the Danish negotiated an exception for their Danish seine fishery. and also the Dutch government, they managed to exclude the whole Zone 5 measure in the joint recommendation. The orange marks, they're also important in that way that, as I said, our Belgian government wanted to make a testing zone for alternative fishing techniques with a permit system. And in the ad hoc working group, so the informal member state group, they asked to ask ICES advice on the permit system. And I was very happy to read in the ICES advice that they had some fundamental questions, like why use a valuable zone for testing? So I was very happy with the ICES advice, but I don't know what Belgium or the European Commission will do with the remarks from ICES on the permit system. I don't know. So when we summarize, the next slide, when we summarize the whole procedure, so before we had our marine spatial plan, the proposed fisheries measures, they were already discussed with the neighboring member states, like the Netherlands. So the fisheries measures that are included in the marine spatial plan, they are already negotiated fisheries measures. Now afterwards, to enforce the measures for non-Belgian vessels, we had to start with the Article 11 procedure, and we see that the measures are weakened again. So they are weakened at least twice during this whole process. Okay, next slide. What did I do from a policy work with Natuurpunt? Well, I think one of the main problems was that I was informed quite late. So the Article 11 procedure was already well advanced. There was already a draft version of the joint recommendation, so it was very hard to influence it. And I attended one meeting of the informal member state group as an observer, thanks to Ian from RSPB, who told me that there was a meeting in Brussels and that I could replace him. So I only attended one meeting, and there it was, yes, I noticed that the proposal was already well advanced. Afterwards, I had some informal contacts with DG Envy and DG Mare. They listened very carefully to my opinion, but they didn't promise anything to make sure that the environmental protection would be guaranteed after all this process. And something I forgot to write on my slide is that the North Sea Advisory Council also made an informal advice, but only from the NGO partners, and Client Earth supported that advice very much. So there wasn't an advice from NGO partners officially given to the Belgian minister. Now, I also had contacts with the Belgian Minister for North Sea, the Flemish Minister for Fisheries, and they also had a very pragmatic approach. They said, well, weakened measures are better than no measures at all, so let's go for them. Now, during the whole process, I felt quite powerless, and I think that also the civil servants from the environmental agency in Belgium felt the same. The Belgian fishing fleet depends very much on the fishing grounds in other member states, so they can't play this game very hard. They are too dependable from the other member states, and I think that's one of the biggest problems for Belgium. So the European forces, they are really too strong for a small country, and also for an NGO in a small country. So European cooperation is very important for these whole procedures. Okay, next slide. So I think it's always important to also have a look on the bright sides. And one good thing is that the fisheries regulations will be implemented 3 years after the approval of the MSP, so that's a good point. It's a start we can go for. The Danish exception is at this moment is theoretical because they only have fishing rights in the two zones, but they don't use them. So I hope they won't use them in the future, but we don't know. So at this moment, it's only theoretical. The measures in Zone 5, which the Dutch managed to exclude, they are in inshore waters. So we can use the Article 20 procedure of the CFP to implement them afterwards. And I think that one of the most important facts in this story is that the Belgian case is an evidence that Article 11 of the CFP isn't fit for nature protection. So I guess it's important to use this example, especially when the CFP will be revisited within a few years. Okay, to end, a few questions for the future. Very strong questions in that point that the Belgian MSP is revisited now. So each stakeholder has been asked to put to give their questions to questions for the next MSP before the end of April. So the whole process will be started again, and that by the end of 2017 we will finally have a management plan for the Nature 2000 zone Vlaamse Banken. So my big question at this moment is, so what will happen if we hopefully have improved measures in the Nature 2000 site? How will they be implemented? Do we have to repeat the Article 11 procedure again or not? I already asked our Belgian government, but they didn't give me any answer yet because they don't know themselves neither. So it's we have measures, they will be implemented, but from the moment they are implemented, we will start discussing new measures again. So it's a bit uncertain what the future will bring for the protection of the gravel beds in the Nature 2000 zone. Okay, thank you.
Thank you very much, Krien, for this presentation. It's very interesting to see the two case studies, the UK one and the Belgian one, and how things have evolved in the same process, let's say, in these two different national contexts, and also how happy or unhappy you are with the results. I think what both presentations show is really the need for coordination, European level coordination, and coordination between NGOs of neighboring countries, countries that share fisheries and that have interest in the fisheries of each other. So that's really what we're trying to do here at Seas at Risk, in cooperation with Marine Conservation Society and Client Earth, what we've tried to put in place over the past few months. Unfortunately, I think it's arrived a little late for your process, Krien, in Belgium, and well, it's not the only reason, because there were other NGOs participating in that process, but it might be one of the reasons why you have felt quite powerless in these different meetings, and hopefully we'll try to provide support to you if there's another Article 11 process happening in Belgium, and to other members who are going through the same thing. One of the things that we did during these past few months, before I go into that, if you want to ask questions to our presenters, now is the time. So don't hesitate to type your questions, and then I'll take them one by one afterwards. But yeah, as I was saying, one of the things that we've done with MCS and Client Earth for the UK process is these template letters that Jean-Luc referred to, and Alice as well in their presentation. So based on the arguments put forward by MCS and Client Earth, we wrote a sort of generic letter that we then sent to our members in countries that have a fishery, a management interest in the fishery in the southern North sites, which were France, Germany, Netherlands, Belgium, Denmark, and Sweden maybe. And we asked our members based in these countries to send these letters with, of course, their letterhead and signed by their directors, to send these letters to their governments, to their Ministry of Environment and Ministry of Fisheries, with the same message. So in the case of the UK, the message was that, overall, we support the proposed measures by the UK, and we would like the government to support them as well. But obviously, this could be different. It could be a different message in another case. So in the case of Belgium, if we had done this on time, the message could have been different considering the measures put forward. What is very important, and that was highlighted several times during the different presentations, is to come in as early as possible in the process, because the real influence can be had really during the informal phase, before member states have effectively agreed on the measures and they go to the formal phase where they submit a joint recommendation. So it's really critical that we intervene at a really early stage of the process. And what we need to do that essentially is information on whether any of these processes are taking place in your country. So through the different European fora and through our contacts with other European NGOs who are also working on this, for instance, WWF and their different national offices are also monitoring these processes. Client Earth is BirdLife as well. Through these different networking opportunities, we are able to get some information as to what is happening in the different member states and whether member states are considering putting in place or proposing measures under the Article 11 of the CFP. However, we also rely on information that you can give us, because you also have close contacts with the Environment and Fisheries Ministries, and you might know better what is happening and what's in the pipeline. So one of the messages that we want to pass on today is really whether, it is really for you to keep your ears open about these processes and let us know as soon as you hear something in an informal or formal meeting about your country presenting a set of measures, conservation measures in offshore areas, because then we can work together and with members in other countries to ensure the best outcome for all of us. So I think that's all I wanted to tell you. I don't think that I have received any questions from any of you. Callum, did you want to take the opportunity to say a few words about the Scottish process since you have joined us. I don't know if that's the case. Yes, so I will unmute you and you can let us know a little bit about the process. Here you go.
Thanks very much, and good afternoon, everyone. Callum here in the MCS office in Edinburgh. Thanks to my colleague Jean-Luc for putting the Scottish sites into that UK context as well. I won't take up a great deal of time. It was just to very quickly add to what Jean-Luc was saying from the Scotland perspective, which was that I've been involved with workshops, as Jean-Luc's slide said, with fisheries representatives from Scotland and some other EU member states over the last few years for a lot of these offshore sites. And one of the things that we pushed for within that process, so there were several workshops going back to 2014 actually, was for the measures to be in the public domain, and we were pushing for that under Aarhus Convention, and we although we didn't succeed in securing a formal public consultation within Scotland, and I can understand why, because the process doesn't require that the Scottish Government does that. What we did manage was to secure a window, if you like, whereby the Scottish Government invited people, maybe at a stage that hasn't been available in other parts of the UK or in other EU member states, to provide their feedback, prior to the advisory council process, both informal and formal. So whilst we wouldn't, as the whole process rolls forward, be seeking to change what the Scottish process has come up with, we have had the opportunity last autumn to put that line in the sand, if you like, in terms of where we think there are some shortcomings in the proposals, where they're not precautionary enough, or where for SACs where we can't be confident that legal requirements will be met. So I can share that link if need be. But as I said, going forward, and as Jean-Luc said, we would be thinking that it's just a case of, I think we'd be happy if we could just get all the measures that are on the table through the whole, European process. And my understanding is, when the Scottish sites are tabled within the advisory council context, there hasn't been any resistance, because the Scottish Government, from other member states, because the Scottish Government has engaged, as I said, the fishing representatives of those states in the process. So, so in summary, we've hopefully put the marker down that outlines the concerns, not just on where we've got more of a legal hook to do that with the Habitats Directive, but also on points of principle regarding the sites under the domestic UK legislation. I hope everybody's comfortable that and shares our perspective that the perfect can't be the enemy of the good, and would be doing well to get all this stuff, all these sites and all the measures for them through the wider process. And just to thank you for setting up the webinar, and I've enjoyed listening in.
No problem. You're very welcome. Thank you for sharing this experience. I don't know if any of our panelists wants to say something about this, but thank you very much, Callum. Yeah, so I don't see any other questions from our audience. So I think that for the moment, this is it. Just want to remind you, so what we're trying to do here at CIS at Risk, as I was saying, we're hoping to work with any of you who is engaging into this Article 11 process in their country, and we can do so by helping with writing template letters that will, of course, be tailored to the situation in your country, and sharing them with our members in other countries, and getting them to support your message, which either supports the proposed measures or doesn't support the proposed measure, depending on what is proposed. As Jean-Luc just reminded me, some environment ministries are sometimes very happy to get these type of letters from NGOs, because it allows them then to confront maybe fisheries ministries and say, look, you know, our conservation people are not happy with what you're proposing, or they are happy with what you're proposing. So sometimes governments are also happy to get this type of support letters from NGOs. We, on the SAR website, there is now a new page on marine protected areas, where we've uploaded a number of documents. There's a link to the workshop and the presentations that took place at the workshop that Monica mentioned before. And there's also now a link to 4 briefing notes on site integrity, which can help guide your arguments when you are reviewing proposed measures by your government. And they're related to different types of features. So there's one on reef, one on sandbank, and I don't remember the other 2. Jean-Luc might remember. Anyway, they're on the SAR website, and you can access them easily. So don't hesitate to have a look. I just got a question from Teresa about whether we'll have access to the video. So indeed, we are recording this webinar, and we will be sharing the recording with you and also with others who couldn't attend today. So we don't know yet what format it will be in, but we know that we will be able to record. So I hope that everyone everyone got a lot of information out of this webinar, and we will soon be in touch, and I wish you all a very good end of afternoon. Okay, bye-bye.
Thank you again for organising. Bye, everybody.
Bye.
Bye-bye.
Bye, and thanks, everybody.